Studies, well, the topic could soon make history again. You'll find the official definition of affirmative action right here at the bottom of your screen, but basically it's designed to make representation at work or school more fair for groups that have been historically facing discrimination. The reason we're talking about it today is because the Supreme Court is expected to hear challenges to affirmative action in its next session, specifically how the University of North Carolina and Harvard select their students. You see, a group is suing both schools, saying the weight the schools put on a student's race in the admissions process is actually more discriminatory than not doing it. And people are calling this the biggest challenge to affirmative action in years. And to explain why, here's a crash course on some previous cases. The last time the Supreme Court heard a case like this was back in 2016. It dealt with how the University of Texas selected students. And then a 4-3 decision, justices imposed strict limits on affirmative action programs, but did not flat out ban them. And obviously, a lot has changed in the last 6 years. For example, how 2 of the 4 justices who made up that 2016 majority are not part of the court anymore. Anthony Kennedy has since retired, and Ruth Bader Ginsburg passed away in 2020. President Donald Trump appointed 3 conservative justices during his time in office, all of which means the makeup of the Supreme Court, and more importantly, the balance within it, has shifted. The group currently suing wants the Supreme Court to overturn a 2003 ruling which helped the University of Michigan's law school admissions program. At the time, the court decided the social benefits of diversity allow schools to take a limited account of race when deciding who they're going to admit. All of which brings us to today. And to help us better understand the latest case and the implications for future students, we're bringing in analyst and constitutional attorney Andrew Lieb. Andrew, thanks for joining us today.
Thanks for having me. What an interesting issue we have to discuss.
Absolutely. But first of all, let's get to the basics. Who brought up the lawsuit and what is their argument exactly?
So the group that's bringing it is called Students for Fair Admission, and interestingly enough, the stockbroker who funds that group also funded the Fisher case that you referenced from 2016. So he keeps coming at this same issue. But I need to point out that it's interesting that you explain the Grutter case and you also mention what affirmative action means. The Grutter case is based on a case called Bakke from '78. And what they said, just to be clear, is it's not based on affirmative action that we can make race-conscious decisions. They actually said we can't make a decision based on affirmative action. Instead, the reason to do it is because a diverse student body, for lots of different factors, maybe age, maybe religion, but also race, contributes to overall learning and makes a robust understanding and prepares students for jobs. So we have to differentiate the two. This isn't necessarily an affirmative action case. It's about whether admissions can have race-conscious decision-making.
So doing a little bit of research here, NBC has been covering this for some time now, as you can imagine. It seems that one of the arguments is that the way the system exists today is more fair for African-American, Latino students, for example. But what I'm reading here shows that I guess the opponents are claiming that the admissions process at UNC and Harvard are discriminatory against white students and Asian Americans. Is that something that we've heard before in the previous cases?
Well, forget the previous cases. Yes, we've heard it before, but we're hearing it every day in society with reverse discrimination. And in each state, we're having battlegrounds about how we have to look about critical race theory and other issues about historic wrongs to communities. But I need to emphasize something that ties into what you just said so perfectly. The Bakke case, that's the fundamental of whether we can utilize race-conscious decisions as a plus factor in admissions. That Bakke case in 1978, and you're going to love this, I'm paraphrasing, said in 25 years, we hope that race-conscious decision-making in admissions will no longer be needed. So the Bakke case in '78 foreshadowed what's happening today, and maybe, and as you said, the Fisher case was 4-3. Now we're more conservative. I'm betting we're not going to have race-conscious decision-making moving forward.
Okay, now you just mentioned more conservative because as we've been discussing here for the last few minutes, this has come up several times before. The makeup of the Supreme Court has changed in the last several years. How big a factor do you think that'll be in determining the outcome of this case specifically?
If I was playing a betting game and I'm not a betting man, but if I was playing a betting game, the last decision, which was Fisher, was 4-3. They only had 7 justices that could participate. One had to recuse themselves. There was a reason why the other one wasn't there. But all 4 that voted were liberals who voted to affirm race-conscious decision-making, and the 3 that voted against it were conservative. Now we have 6 conservative justices to 3 liberals. Sometimes Roberts goes back and forth, so even a 5-4 decision. And again, I have to emphasize that the Bakke case, which was upheld in Grutter and then in Fisher, all these liberal justices, they themselves predicted that hopefully in 25 years from 78, which was long ago, they would reverse this. So if I had my crystal ball, I think it's going to change. And I want to emphasize one more thing. A very similar law happens in employment. And so the same concept, can we take race into factors? Can we take religion into factors? Can we do other DEI, diversity, equity, and inclusion efforts? That's all going to be before the court of the next term, which starts in October.
All right, Andrew, let's say this is a shifting of the tide, and it could have implications for the workplace, for, higher learning as well. We're going to have to obviously wait and see what happens, but I wanted to thank you for joining us. Constitutional Attorney Andrew Lieb, thanks for joining us today. We're going to see what happens, and depending on what does happen, we'll check in with you again.
Looking forward. Thank you.
Thank you for that. Eric, very interesting stuff. No